Objection, my lord. Objection overruled. Lawyer Papa.
Where did you graduate from?
Your Honor, Ghana School of the Law.
Ghana School of the Law.
Of the Law. KJT.
What? Is there something like that?
Oh yes, there is something like that.
A law school?
Yes, Your Honor.
And how come I don't know about it?
I don't know why you don't know about it. Ghana.
Which chamber?
Oh, from the Chamber of Port. Chamber.
Because me who say Supreme Court air trend number 1. High Court and so air trend monka highway because it's all about election dispute who essence and parliamentary side easy or your Re-Collation. Supreme Court wakasa. NDC for me who so jubilate. Ending for so chima kai near Canadian Kosiaga. Electoral Commission side so be chima. Hey, my name who smoothness level. Mobian jubilate answer and Samono. Me betrim. They are some they see court for mama videos. Lawyers need na make argument. Masterwa, so be share video we now be share wadwe amame or comment section. Once subscribe here, Masterwa. So be subscribe to TRENDSGH. Na turn on notification bell on for latest update. Now some na feel ebusia, ma min church terms no draw song. E need to know eya na wo dey ateme. Me nkese bebre. Me bon tofa. Se na be ya. Wo beti ase yi. So ebusia 7th December na Ghana yeto aba. Na yeto aba wie ye no. Na just say parliamentary side no NDC MPs nibi. Ai omawini. In fact, it's on video. Say, EC returning officers no omanka so omo declare say those constituencies in question no omo declare almost omo no omawini. But ebusia after that no NPP MPs ni chire mu say omo ntia ase enu nti no omo de omo beko court. Now before that na ebusia electoral commission oba bonti be chire mu say omo ankasa no returning officers ni bi ho kra na omo declare results no ema NDC na they were under duress. I had to say in Shebi na dey bi ho omo make that declaration no enu nti no omo besa a Re-Collation for. Now enu na ebusia 16th December NDC omo call high court say court and stop EC say oni ho kwan so be a Re-Collation na was say declaration for because omo di nkan aye saa de no dada. And on a fast forward, NPP MPs no almost 17th December, Omoko High Court, Omuchemu say, Eja High Court judge, yes, Rawa, Electoral Commission, or you may be a Yeneno and Yadri, and you know, Yabasra was said, who High Court judge no, use power, not share easy. In Bremone will be a friend of Mandemus, and one and say, Court no and share easy say, Uncle collation, now if you won't declare winner, I hear you say, so mu declare there, here NPP MPs now. Beginning of much say you lose no here and you be winning. So it was a high court judge no yes or no the assam. Now it's on record say NDC or more mudi kind of assam echo court 16th no high court judge no when this assam no but OD NPP or more the court 17th no the same high court in front of the same judge. So fast forward it was easy or more re-declaration no for now ahana assam no and no some lawyer Edu Tamaklu or the assam no kopie Supreme Court said I just Supreme Court or Moshe no more BB. And some also Supreme Court no more ye.
My lords, our ground for this application is that the orders made by the High Court were made in breach of the applicant's rights to be heard. My lord, the further ground is that the trial judge demonstrated apparent bias and partiality. 3, that there was a non-jurisdictional error of law by failing to exercise the court's powers under Order 55, Rule 5(2) of CI 47 to direct 2nd to 6th interested parties to serve the mandamus application on the applicants who have interest in the subject of the dispute. And finally, error of law apparent on the face of the record, which error of law occasioned a substantial miscarriage of justice to the applicants. My lord, an application for mandamus was filed before General Jurisdiction 13. Now, at the hearing of the said application, after counsel for the applicant and the respondent announced themselves, I drew the court's attention to a joinder application. The trial judge, the trial judge requested I show him a copy of the joinder application. He therefore asked his clerk, a lady clerk, to come for a copy of the joinder application, looked at it, and proceeded to write his ruling.
So, and your point is?
The point we are making is that at all material time, the fact that was before my Lord was that the applicant herein, whose interest will be affected by that decision, ought to be heard. And that failure to afford them a hearing before the decision was given offends the Odi Ateron Parting Rule. And that offense cannot be cured and should result in the invalidation of the decision by the trial judge. It is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court, my Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned.
Now, in fact, lawyer Edu Gichamakru Ochemukra no just say ebi ohoma o make it clear say high court judge no or your bias because omo NDC for kra no omo kire na say papa won't me say isi say onko read declaration because ya kire video wa e no kire say declaration no akọ in favor of NDC. But ebusuan Edu Gichamakru can ansam na say judge no went your master no Supreme Court judges no omo ankasa no they were shocked.
The applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even found ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
No, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. But my Lord, these are declarations with video evidence. So consider my application first. He ignored it. At the time my Lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it and started giving his ruling. My Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the mandamus. He knew that that would definitely affect their rights. So, my Lord, it's on this basis that we invite this honorable court to quash the orders of the High Court General Jurisdiction 13.
Maybe you don't mean to be chow. So, and the Electoral Commission, lawyer, no, you're sorry, yes, sir. Objection, my Lord. Kind and the way Natalian say, say yes, and then the rebel court. Oh, Chemu say, or want some kind, now interesting. Ono ankasa nsam na o kan edu baby a judge ne kra no try say papa o kan say anke bebua o. Now the underlying word is manya.
So far in the submissions, I have not heard any submissions to say that the judge erred and that error is on the face of this record and is jurisdictional and therefore Sesurera should lie. Respectfully submitted. Thank you.
Oh, Counsel.
Right.
But you argued Hawaii Yakubu in your. You argued Hawaii Yakubu.
Yes, my lord, I did.
And Hawaii Yakubu, the decision was that if the party in an election will be affected.
No. My lord, the order had an injunction placed. But in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my lord.
As happened in Hawaii Yakubu.
Yes.
And I read your submission where you try to distinguish Hawaii Yakubu.
Yes, my lord. And then also, one last thing, now that you have brought it up, my lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my lord will look at it as an application. My lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you.
Counsel, take your time. I like the word mania.
So after this in Ebusia, NPP, omo lawyer, Mr. Gary Nimakon, ono so the sorry ya. O chem o cancel bebre say oh wo hwe isi no ne awaye na just ono de no kwan so ano no in fact
My lord, the High Court only made an order directed at the public body to perform public function, to simply go and collate and declare a winner of a public elections. And my lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, who the court made for the EC, the first to go and collate and declare who has won or who has lost. My lord, it's a public function. It's a public function. How does that order to go and collate and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your exhibit 9. Look at your exhibit 9. D9. Your exhibit D9.
My lord, exhibit D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation
D9,
sheet.
Yeah, it's a public document.
It's a collation sheet.
Which is a parliamentary election result summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the coalition and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My lord, with all respect.
Because they have a right even at the administrative level to object.
Yeah, my lord, under the CI 127,
Yes.
if a party decides not to participate in the process,
Yes.
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There is nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My lord, with all respect to you, the bench, this document D9 that you are referring to, this becomes relevant when the results are gazetted and you want to challenge the result of an election petition. My lords, with respect, at the time when the court was making an order for Madam's application, this exercise I don't know if effective. But now, personally,
I'm just trying to say that what the applicants are saying that they stood to be affected, and you are saying that they would not be affected. The Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Minubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you. But it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my lords, I mean, this particular exhibit D6, 7, 8, and 9, its contents therein were not factored in at the time when the court making an order that proceed to go and do collation and declaration.
Okay, agreed.
In any event, my lords, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, they did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed.
Oh,
foreclosed.
If that were the law, the illegality will persist forever.
My lords,
so I'd like your other arguments, but as for foreclose,
my lords,
your other arguments you have answered substantive.
My lords,
yeah.
My lords, an order by a court to proceed to perform a constitutional and statutory function.
If it's set aside, that would be, the consequences are clear in the authorities.
I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that another High Court judge exercise a discretion. If the applicants are agreed about the discretion so exercised by another High Court judge, their remedy lies in an appeal and not, my lords, we submit accordingly.
Thank you.
My lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
I have authority to give him. I have authority to give him to go to appeal. He is there. And I will give it to him. Yes. 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 The authority is there, I'll give it to him.
So Supreme Court judges never so much afani afani in every year no musi oh after the my judgment. Now and some more can in now ebusia. Hana some one.
Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of the Akufo-Addo and Ahafo North constituencies per paragraph 8 of the affidavit sworn to by 50 Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaigwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafuanon North are not affected by this order, by this our order, and in effect, those declarations stand. Despite questioning the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statement of case in answer to the respective applications for mandamus which have not been quashed. Now, those which have been quashed, sorry, those which have been quashed, yes. As interested parties, the time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte Ajua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, extremely grateful.
We are grateful to the court. My lords, we are grateful.
So judgment when the Supreme Court omodi tuga. Now momentum ebo na me breaking it down. Nia Supreme Court omo kani nyina na se omo etie afane afa obia aka nesem na omo so de omo judgment a omodi tuga no. One, eno ne se some of the constituencies asesia no omo twe homa so no mako 6. Now, out of 6 no, 2 Nsawam Adwajiri ene afi Ahafuano North de omo chiremu a nia High Court judge no kan ye no ana se easy Re-Collation and I say declaration on moya no eno de eno ano no inteno those 2 seats no NPP omwe wini fencham. Number mono 4 constituencies Techiman South, Tama Central, Okaikwe Central, any Ablekuma North de Re-Collation ECA no foforo no oma cancel. Previously, old one no mo ye na Baba Sadiq be bright any Techiman South MP no I omo de omo wini ye no eno ene sesi aye kasa na de omo no mo ye MP elect. Number no say NDC omo aka say High Court judge no wentie omo asem a wasan aye bias no enu nti no omo Supreme Court omo chiremu a eye 31st Tuesday we no asam no different High Court judge ebetna that asam no so nene de omo ahwe no mu de ye atu ye enti na Supreme Court o kan nyina na say empepre ya ye kese de dada no NDC MPs no omo wini those 4 constituencies na mebobo so no omo no omo ye MP elect until further notice ebusia different High Court judge obetna asam no so obetie NDC for nkomo wetie EC na wetie eye NPP for ehun fata so obama EC no mandamus ne say onko na onko ye Re-Collation foforo anasa ma no nkoye inti as it stands now no ebusia Baba Sadiq be bright omo na ebusia those 4 constituencies no omo ye MP elect inti say ene ekosi ye wo Supreme Court just say NDC for no omo jubilate NPP for no chima they say we put there until further notice inti no there what the Afriex say be play your cards here say your court na say High Court judge no or grant say say see ade ensan koye collation for fra e ho ene mu be hu smoothness level but until then Baba Sadiq be bright omo no mo ye MP elect plus 2 others. Now Frank Anodompre NAFI NPP parliamentary candidate or no so or represent half no north no Supreme Court aja to say declaration e course no and one no ebusia my bra yi sire wa dwema me or comment section ho na share video we ma for so ensa NKB man debus no de e was me apply v.
Hey family, this is Dr. Badu. I can't wait to see you at the Fifi Prat Polo Party.
On the last Sunday of the year, jump up to the Marina Mall Soho from 9 p.m. It's Fifi Prat's Polo Party popping up on the 29th of December 2024. Sunday at Soho. Wear your polo top and experience lots of fun. Thrilling games with hot DJs on rotation. DJ Mensa, DJ Allegation, DJ Baylor, DJ Chihuahua, and Fifi Prat, the Supercharger. Hosted by Nia Itego. Call 0509823414 or 0244319741. For reservations, it's Fifi Prat's Polo Party, supported by Kingdom FM, Peace FM, UTV, and JL Properties.